receive under these acts and these requirements. So starting right off with the Fmla Expansion Act, it basically extends the FMLA, it expands it beyond its current scope. It provides for up to, these expansion requirements provide for up to 12 weeks of protected leave for employees who need to take time away from work. 10 of those weeks will be paid. The first 2 are not paid if they are needed to take time away to care for their children. It has a very limited scope. Contrary to what you're going to learn about and what we'll talk about when we're discussing the Emergency Paid Sick Leave Act, the rights and protections under the expansion to the FMLA are very limited, and we'll see that as we go through the details. So starting right off is the question that most folks ask is to whom does that act apply, this Expansion Act, the specific provisions that expand the protections under the FMLA? And the answer to that is it depends on the employer and it depends on the employee. We'll talk first about employers. It applies to employers with fewer than 500 employees. So typically under the FMLA, it was usually the larger employers that were required to comply and will be required to continue to comply with respect to the other provisions, the other existing provisions under the FMLA. Those will continue. Larger employers will have to comply with those requirements. But this particular nuance, this subsection F protection, is going to be expanded to employers of 499 employees or fewer. If they're private employers, and then all public employers will be required to comply. There is going to be an exception, a possible limited exception. It depends on an act that's going to be required of the Secretary of Labor. And we should see some regulations coming in here very, very soon from the Secretary of Labor in the coming days that hopefully will address this possible exemption. And that will apply to employers with fewer than 50 employees, where to comply with the requirements under this enactment would require them to possibly jeopardize their business viability. We don't know exactly what the permutations of that are going to be, what the nuanced requirements are going to be yet. We're waiting on decision-making by the Secretary of Labor for application of that exemption. It also applies beyond targeting just employers of 499 employees or fewer. It also applies to employees who've been employed at least 30 calendar days. So traditionally under the FMLA, I think most employers are familiar with this, it only applies to employees, and will continue, the other provisions of the FMLA will continue to apply to employees who've worked for the employer at least 1 year, who've worked at least 1,250 hours. All of those will continue going forward. When we talk about this particular right to leave under this new Section F, it will apply to employees who've worked at least 30 calendar days. So we'll kick in very early into an employee's employment with the employer. They'll have the right to exercise leave under this new provision. There's also an exemption, and we don't know the particular nuances quite yet. We are again waiting for some regulations from the Department of Labor and the Secretary of Labor, but there's going to be an exemption for employees who are considered healthcare providers or emergency responders. And we don't know, again, exactly how those terms are going to be defined. We will hopefully address those in the regulations that should be coming in the next few days. The question also comes up, when can it be used? And to start, it doesn't begin until April 2nd. That's the start date of this new right, this new entitlement, and it will extend all the way through December 31st of 2020. It then expires at that point. Might there be further act of Congress to extend it further? Certainly that might be possible, but that is the window during which individuals will be protected and will have the right to exercise leave under this provision. It will apply to employees who are unable to work or telework because of a need to leave to care for a son or daughter who is under 18 years of age, because that son or daughter's place of school or childcare has closed because of a public health emergency, which is defined as a declared public health emergency because of COVID-19. So again, it has very limited reach. It only applies in those circumstances. It only applies when the employee needs to take time away from work, they need leave, they're unable to work, unable to telework in order to care for a child who can't go to school or whose child care provider can't provide the normal child care because of COVID-19. So that's the limitation on the right under this enactment. What do employees receive? What sort of entitlements do they get? Well, as I indicated before, they get up to 12 weeks of leave. Under this enactment, the first 2 weeks are unpaid. Now, interestingly, this does dovetail, and you'll hear more about this when John Belitis talks about the emergency paid sick leave law. Those kick in during the first 2 weeks, but for the first 2 weeks of leave under this enactment, it will be unpaid. The next 10, if an employee is eligible, qualified, and takes the leave they are entitled to take under this law, the next 10 are paid at 2/3 their normal pay rate. Now, there are caps. There's a $200 a day cap under this law, and there's a $10,000 in the aggregate cap as well, which $200 a day multiplied by 10 weeks will equal that $10,000 cap. There will also be, as Otto will address here very soon this morning, there will be tax credits that employers will be able to take advantage of to help defer the costs of this leave and the pay that's provided under this leave. The pay computation for employees who've taken this leave are at the regular rate of pay, and that includes all compensation. Important that employers be aware of that. If employees normally receive commissions, if they receive bonuses, if they receive additional pay aside from their base salary or base hourly wage, that will need to be factored in when calculating how much employees are entitled to receive when they take leave under the Act. If employees have a varying work schedule, employers also need to average hours taken over the past 6 months to determine how many hours those employees typically work and coordinate to make sure that they receive the average hours for which they would get paid while they are out on leave. So all of that needs to be taken into consideration. And at the end of this, when employees are finished with their leave, either they've used all the available time that they're allotted under this new provision, or in the alternative, if they're able to return because the childcare and school arrangements have picked back up again and that their kids go back to school, then the employer has a duty to restore the employee back to their original position. There is a very limited exception for smaller employers who have less than 25 employees. Those employers may not have to restore individuals to their positions if those job positions have been eliminated, and they've been eliminated because of the coronavirus. Very small employers do not have to restore individuals back to their original job positions. The interesting thing about that, though, is the employers, even though smaller employers nonetheless still have to provide the leave benefit. The employees are still entitled to the leave. It's only when the duty kicks in for the restoration of the job, when the individual is ready to return, the employer, if it's small enough, will not be obligated to restore them to the position. They nonetheless have to also consider other available equivalent positions. And then they have a duty, a 12-month window during which they still have to try to bring that employee back if they can. If things improve and they're able to restore that position later, they essentially have to keep that employee on a call list and give them a call and see if they can put them back in their job. So those are a lot of the general requirements. There are a few very important notations that I want to remind employers of under this Act. And the first, and I've mentioned this a few times before, the rights of leave under the expansion of the FMLA, this additional Section F, is very limited. It doesn't apply, these new terms do not apply to the other rights of leave under the FMLA. Employers don't have to provide paid leave under the Fmla Expansion Act if somebody takes time off because they're sick, because they have a child, that doesn't have to be paid leave. But the existing FMLA provisions that have been in place before the expansion will continue. Employers of 50 or more employees still need to be cognizant that employees will have the right to take unpaid leave provided for under the FMLA. That will continue. That has not changed. Similarly, the duty to restore employees to their job positions under the FMLA, the other provisions will also continue. So employers need to be cognizant of that. They do need to also be aware that although the rights granted under this expansion are very narrow, there are additional rights that are granted under the emergency paid sick leave law that John Belitis will be talking about that has much more expansive reach, and employers should be aware of those rights. And although the right to paid leave under that enactment is a shorter term, it does provide greater protection for employees to take leave for instance if they have their own illness or sickness related to COVID-19, and John will talk about that. Second aspect that I definitely want employers to be aware of is that these leaves should be well documented. There are various leaves that are going to come into play, various rights, overlapping rights under state law, local law, these different legal requirements under the FMLA and under the new Emergency Sick Leave Act. And so employers should be very cognizant of their responsibility to properly document the leave. Not only is it important for ensuring they protect their employees' rights and give them the entitlement of leave that they have received under both the law and policy, but also for purposes of tracking the credits. At some point, obviously employers are going to be seeking to use these credits on their taxes, and so having all of the leave properly documented is going to be absolutely instrumental. So with that, obviously there's a lot we still want to talk about, and we want to leave adequate time at the end for questions. We're confident we'll get quite a number of those. I'm going to go ahead and pass this over to my colleague, John Belitis, who will be talking about the emergency sick leave law. Thank you. Yes, we seem to be having a slight difficulty. We'll be connecting with John here in just a second. You can bear with us. And just to, again, reiterate, this goes into effect April 2nd and will run through December 31st. It's the same with the sick leave law. And employers need to be mindful, although they may want to start providing some of these benefits now. And certainly they're entitled to. They can always go beyond what these legal requirements provide. They have to be cognizant of the fact that if they provide leave now, it's not going to apply against the caps. It's not going to apply against the requirement that starts April 2nd. And it's also important for the credits too. I do not believe, and Otto should hopefully be able to address this, I do not believe that employers who start providing some of this leave early will be entitled to the credits on this early leave in the next week and a half until the law goes into effect. And so with that, I do believe John Belitis is ready to go. Oh, okay. I was mistaken. John Belitis is not quite ready to go. But we want to make sure that we do address some of these issues and see if we can proactively address some of the questions. Maybe while we're waiting on John Belitis, I can ask Otto if you have any thoughts on questions that maybe we can entertain here early.
Chris, I think one thing to note is that it's rapidly evolving out of statutes, regulations, notices, and the point about the effective date, the language of the statute says that it's effective, I believe, no later than 15 days after the date of enactment, which would be April 2nd. But at least with respect to the tax issues, the Secretary of Treasury can add an earlier effective date. So I think we should all watch for the regulations and the guidance to come as to what dates are going to apply.
Absolutely, and that's a very good point, Otto. And as Otto had pointed out, we are waiting on quite a number of regulations from the Secretary of Labor, the Secretary of Health, Secretary of the Treasury. All of those regulations are going to impact precisely how employers need to apply these new leave rights and when some of them go into effect. And so it is very, very important that we pay attention to that. Along similar lines, Congress is already considering a corrections bill, and we've already seen an early draft of that. How that might evolve before it's actually adopted remains to be seen, but we're going to see some corrections. As I believe most folks understand, this was put in place at a rapid pace. Legislation typically takes a long time running its way through Congress. And so our Congress, in the interest of acting quickly and getting money to people and providing for additional protections, they have left a few gaps, a few oversights, maybe even a few inconsistencies in some of the legal requirements. And so we are already seeing a Corrections Act that hopefully will be finalized here in the near future. and passed. So we want to be on the lookout for that as well.
Well, and Chris, I think we're seeing the response evolve as things become more serious. I think the government's stepping up its options. We participated in some meetings with the Arizona congressional delegation and the message from them was that the government was looking at all possible ways to get liquidity to the employers and the employees as quickly as possible. So the indication from an economic standpoint was that unlike the 2007-2008 problem that we experienced, in this situation, there's lots of liquidity and it's getting the liquidity to the right places. And so I think we can expect to see more evolving changes. The Internal Revenue Service has already put out 4 different pieces of guidance and more is supposed to come this week, for example.
Excellent. And that's absolutely right. We're going to see a lot of information, even with some of the ambiguities that we've identified. There are differing interpretations amongst the labor and employment attorneys who've looked into these things. So we need to be cognizant of that as well. Because of the ambiguities, some of the uncertainty, we are providing answers, we're providing our analyses, but we have to recognize some of this is going to continue to evolve as we get more information and more guidance from the various government agencies. All right. Do we have John Belitis ready to go?
No, we don't.
Okay. You got it.
We can do that.
Yeah, we'll go ahead. We're going to continue. Unfortunately, we were unable to have John Belitis join us. We had some technical difficulties. He was joining us remotely. But we'll go ahead and dive in. We'll talk very briefly, and I will encourage my colleague Otto also to chime in. We're going to talk about the Emergency Paid Sick Leave Act, which is also an additional sub-act within the Family's first enactment. And what we're encouraging employers to do and to be mindful of is they really need to track each of these rights, each of these responsibilities separately. We cannot lump them all into the same bucket because there are variations between these different laws and these different requirements. So we want to be fully certain that we are fully complying to the extent that we can, just to ensure that we're not making any errors. These laws do interestingly dovetail together. As I mentioned earlier with the Fmla Expansion Act, the first 2 weeks are unpaid, but there is a provision within the Emergency Paid Sick Leave Act which allows for paid leave during that first 2 weeks for the exact same reason that the Fmla Expansion Act provides, except those first 2 weeks are paid. So you can see how those two laws are intended and designed to dovetail together. The Emergency Paid Sick Leave Act, just like the Fmla Expansion Act, applies to employers with 499 employees or less. It provides for the right for paid sick leave up to 2 weeks, 80 hours, for one of 6 different circumstances. Number one is if the employee is subject to a quarantine or isolation order related to COVID-19. Number 2 is if the employee is advised by a provider to self-quarantine because of COVID-19. Number 3, if the employee has symptoms of COVID-19 and is seeking a medical diagnosis. So they don't know yet whether they have it, but they are demonstrating or exhibiting symptoms of it. They're also entitled to protected paid leave under this enactment while they seek the diagnosis. Number 4, and this is the provision that overlaps directly with the Fmla Expansion Act. If the employee is caring for an individual, a son or daughter, because that son or daughter's school or place of care is closed because of COVID-19 precautions, the employee is going to be entitled to 2 weeks of paid leave under the Emergency Paid Sick Leave Act. Number 5, if the employee is caring for an individual who's been subject to an order under subparagraph 1 or 2, in other words, that individual is subject to a quarantine or isolation order. They've been advised by a healthcare provider to self-quarantine, and your employee needs to take time to take care of that individual. They're also going to be entitled to the leave. And then lastly, if the employee is experiencing, and this is sort of a catch-all, and again, another area in which we are waiting for some regulations, but it says if the employee is experiencing any other substantially similar condition specified by the Secretary of Health and Human Services in consultation with the Secretary of Treasury and the Secretary of Labor. So that's, again, another area where we're waiting for regulations to understand what that provision is going to provide for. Employees who elect their rights take leave under the paid sick leave law are required to notify their employer, and employers are required to provide that leave. Again, it's up to 80 hours. Full-time employees can take up to 80 hours of paid leave if the paid leave is for reasons 1 through 3. So if the employee is taking the leave because they have been quarantined or isolated by a government act, or because of their healthcare provider, or they're experiencing symptoms of COVID-19, that 80 hours has to be at full pay up to a maximum of $511 a day. It's a full pay provision if reasons 1 through 3 are being used for the sick leave. If reasons 4 through 6 are being used, however, it's at only 2/3 of their normal pay, up to $200 a day. So it's a different calculus depending on the reason for which the employee is taking the leave. And for that reason, I go back to a point that I made earlier. Employers really need to do a good job of documenting the leave, knowing the reasons, understanding the reasons, making sure they have clear communication with employees who are taking the leave, because the rights, the entitlements, and the responsibilities are going to vary depending on why the employee needs time away from work under these different enactments.
Chris, let me ask you a question there.
Absolutely.
We, we have the Arizona Sick Leave Act as well, and a public emergency is one of the qualifying events. So how does, and under the Arizona Sick Leave Act, you can't ask for documentation until 3 days. So how does this deal with that requirement?
Yeah, and there are ambiguities because these laws don't necessarily as concretely address some of the overlaps that may come into play with these differing laws and these different rights and responsibilities. What we are advising employers is to treat each of these different laws separately and distinctly. If an employee is specifically using leave provided for under this enactment, employers do have the right to get some information and documentation to confirm the right to leave. They won't know whether or not an employee is protected under this enactment unless they ask those questions. They won't know whether or not they're going to be entitled to use or rely upon the credits that are authorized by Congress unless they get that information. So it is our opinion and our advice at this point. Again, we're waiting on some regulations to see if that changes. But at this point, if an employee is attempting to use rights under this enactment, the employer has the right to ask. When applying, however, the paid sick leave entitlement under Arizona law, the 5 days that are allotted for, if an employee is using leave for any other reason, employers need to be mindful that they cannot require anything more than Arizona law authorizes. So you're right, Otto, to go to your point, if somebody takes time off, they say that they're not feeling well, or just to give you an example, that wouldn't fall under either of these two new laws. If an employee has a car accident and needs a couple days to recuperate from the car accident, that clearly will not fall under these legal entitlements, under these leave rights, under these federal laws, but would apply to the state law. The employer shouldn't be pushing for documentation unless the employee's been gone 3 days or more. And at that point, they do have the right to request the documentation. So going back to the principal point, employers should treat these leave rights distinctly and separately and put them in different buckets, both for administrative purposes, also legal requirement purposes. Employees who take the leave have not to be retaliated against. The computations are very similar under this enactment as they are to the computations for paid leave under the Expansion Act, the Fmla Expansion Act. There are a few differences for employees who work part-time. Employers need to make sure that they do the calculations correctly using averages for part-time employees under this enactment to make sure that those employees are getting paid appropriately. And remember, again, employers have to be mindful of the reasons why the employees are taking the leave. There's a $200 a day cap for reasons 4, 5, and 6, and a $511 a day cap for reasons 1, 2, or 3 under the enactment. Employers definitely need to be cognizant of that when they're applying these leave entitlements. With that, I'm going to turn this over to my colleague, Otto Shill, who's talking about the tax credits that employers can receive under these enactments.
Good morning.
See, sort of.
Bob, you didn't rewipe the table down. Well, we're happy to be with you. We hope this is helpful to you, and we're available for questions. And we'll have some here afterwards. As I said earlier, the goal of the government is to get liquidity to people as quickly as needed. They're using the employers as the conduit to get that liquidity down to the employees who need it. Because many of you and many employers across the country are faced with either laying off people. One of the big debates we've had over the last few days is there a difference between furlough and what can employees expect? And so getting liquidity down is important. So the federal government has provided 2 tax credits, one for the FMLA leave, the child care leave, and one for the paid sick leave. With respect to paid sick leave, you get up to 10 days worth of leave. It's either the $200 a day for reasons 4, 5, and 6 that Chris mentioned, or is $511 a day for reasons 1, 2, and 3 if you're quarantined, either mandatorily or because a doctor has told you you should be quarantined, or if you have to take time off to take care of a child that's quarantined, then you get the higher pay rate. And so the sick leave granted and the credit is granted for those reasons. Initially, the sick leave was to be paid out of the employer's side Social Security tax deposits. You remember that that's 6.2% of wages paid. Well, as the weekend has progressed, the Internal Revenue Service was concerned that that wasn't enough, and so I believe it was Saturday morning, they issued a joint notice with the U.S. Department of Labor indicating that now all payroll tax is available to cover these credits. That's very important because now an employer can consider both employer Medicare and FICA, employee Medicare and FICA, and the income taxes withheld from employees for purposes of offsetting the credit. The employers are able, under the new notices and more information that the Internal Revenue Service will issue this week, to offset their anticipated credit against what they would otherwise deposit with the government. So, for example, if you owe $8,000 in aggregate payroll taxes for your entire workforce and you have paid leave obligations under the Federal Paid Sick Leave Act and the FMLA Act of $5,000, then you only have an obligation to deposit the remaining $3,000. We'll have to see what the IRS comes up with forms and calculations about how that will work. But the idea is that rather than making the tax deposits, the Internal Revenue Service will allow employers for the time being to simply retain those funds and pay them to the employees for the paid sick leave and the FMLA leave that's necessary. There are some limits. As I mentioned, with respect to paid sick leave, the limit is 10 days worth, the amount of the benefit that the employers are able to, or the employees are able to get. In addition, I'll mention, and this is another evolving situation, about a week and a half ago, the Internal Revenue Service issued a notice indicating that high deductible medical plan would be permitted to provide COVID-19 testing and treatment without copays and the usual cost sharing that comes with a high deductible plan. You'll remember that high deductible plans typically are tied with HSAs so that people can pay a lower premium for their insurance, can then deposit funds into an HSA or health savings account and have money set aside on a tax deferred basis or tax favored basis to be able to pay for healthcare costs. Well, now this act has changed that, and now the testing and treatment designed to figure out if preventive measures are necessary is exempt under the act, and so the plans now mandatorily have to provide it. And in addition, the legislation extends that to government-provided health benefits such as Medicare, Medicaid, our access program, those sorts of things. So to the extent, and again, regulations are coming, but to the extent that employers incur additional cost to maintain group health plans or other plans that provide those kinds of benefits, then those costs increase the amount of the tax credit. So important to know. With respect to the Family Medical Leave Act, then the number is a little bit different. The employer is, or the employer is entitled to a credit equal to 67% of those paid. Actually, I need to double check that. Sorry, there's a lot going on. A lot's been changing. 67% or $200 a day. So it ties back to the FMLA leave. The other thing that I would mention in the case of both credits, self-employed individuals also have the benefit of these credits. To be entitled to those, they have to be actively engaged in a trade or business. So those of you who are engaged in hobbies that don't quite get to trade or business may not be good enough. We'll have to see again with regulations. We have to be actively engaged in trade or business. You would get the benefit you would otherwise be entitled to if you were employed by somebody as an employee. I will note that if you are a self-employed individual and you also have an employer, then the benefit you can receive as an individual is reduced by the amount that your employer pays. Those are the credits. Let me mention a couple of other things that I think are important. I've mentioned the group health plans. Also, the Internal Revenue Service has extended both payment deadlines and filing deadlines. That's come in a couple of tranches. The latest notice was issued just this morning, and it provides that for anyone with an April 15th, 2020 filing deadline for an income tax return, that's business entities, individuals, trusts, estates, those deadlines are automatically extended to July 15th. There's no need to file an extension request. The deadlines are automatically extended. But remember, that applies only to federal income tax. In addition, tax deadlines or tax payment deadlines that were established for April 15th have also been extended. That means that if you have a quarterly tax deposit due April 15th for the 2020 year, then that deadline has been extended also to July 15th. So both payment obligations and filing obligations with respect to federal income tax, only income tax. Want to emphasize that. Finally, I think it's important to recognize that Governor Ducey has been active in taking care of getting liquidity to employees, and so he issued a executive order late last week or over the weekend. I think it was Friday night, making available unemployment benefits without waiting periods and without employees having to establish that they are readily available for work and trying to get work, to the extent that you're forced to stay home because your employer has significantly reduced the workforce, or because you have illnesses or other things related to the COVID-19 problem. And so individuals can immediately apply for unemployment benefits. And I guess we'll talk a little bit more. Chris, do you have any thoughts about unemployment benefits versus have to cut back your employees versus how those dovetail with the benefits that the government's providing?
As far as the 6
Yeah, you've got 6. Oh, Chris, we're lighting Chris back up.
Sorry about that for the delay. Could you clarify?
Well, what I'm wondering is Governor Ducey has made these unemployment benefits available. It specifically says, let me find the wording. It specifically says that an individual whose employer has permanently, temporarily ceased or drastically reduced operations due to COVID-19, and it's resulted in a reduction of wages, individuals who, due to the requirements of the individual quarantine, are not able to work and do not have any available paid leave, individuals that leave employment due to the risk of exposure, or another scenario where somebody's separated from work. So those are, if it's any of those, not all of them together. Any opinion about how would deal with the federal paid leave and FMLA leave?
Certainly, if employees are taking paid leave, generally they're not going to be entitled to unemployment. Now, that there is the question if they're taking a drastic reduction in pay because their hours essentially have been cut back related to some of the leave requirements, might they be entitled? And that's a question that I don't know that we have a concrete answer for. But the vast majority of employees are still going to be employed. They're still going to be receiving pay. Generally speaking, at least 2/3, and for at least some of the reasons, they may get 2 weeks of full pay. They may also be entitled to some paid leave under their existing employer policies. They may have accrued PTO, accrued sick leave. So all of that will need to be considered income to disqualify them from unemployment, at least for some time period. Each individual employee, though, I think should be very mindful of when their hours start to drop. If they end up getting furloughed, even though their employment may be continuing, even though they may receive some pay, they may see the amount of unemployment compensation.
Yeah, I think it's important to re-emphasize that employers are not allowed under the federal laws to force an employee to use up other leave before they get the federal benefits. That's different than this edict from the governor. In this case, unemployment's kind of the last resort. So you want to keep that in mind, and we suggest you work closely with your advisors. I suppose this is a good place to also mention that you have other benefit plans that you routinely maintain, 401 plans, for example. You may have deadlines under those, notices that are required. If you have a safe harbor plan, you stop making safe harbor contributions except in certain circumstances. Whether it qualifies for that kind of relief is something that needs to be considered. Also, if your workforce is out of work, most health plans typically tie eligibility for health insurance benefits to being normally at full-time work, and they'll specify often an hours requirement. So it's very important to review your insurance policies and programs. If you're self-insured, you need those as well. Determine what's going to happen to your employees to the extent they're off work for an extended period of time. As you can tell, the federal government's anticipating 10 days, and it was what they could get done quickly. It's unclear yet how long this problem will go on or how big it will get. Hopefully, this week will not be as dire as some are predicting. We'll see. But it's important to look at your benefits on a comprehensive basis to make sure that you're compliant with your other legal obligations. I think we're ready for questions.
I think we are. Absolutely.
Okay, are we good? Okay, we have questions. And these might be things that you have answered in some fashion, but just so we make sure you do answer the questions, I'm going to ask them again. First question, will this webinar cover furloughs and layoffs for small companies? So if you could maybe speak to that a little bit more.
Chris, do you want to?
Yeah, and feel free to jump in. We've obviously both been getting quite a number of questions and calls about furloughs and layoffs. In broad brushstrokes, a lot of employers are furloughing employees right now, which is understandable. We've got many businesses, particularly when we look into some of the service sector areas, restaurants, hospitality, hotels, airlines. Quite a number of businesses have been impacted very hard by the restrictions. They're putting a lot of their employees on furlough. They're entitled to do that. There's no question, no doubt about it. And employees who have furloughed may have an entitlement to apply for unemployment compensation during the time of the furlough. So those individuals should be cognizant of that. And I think that kind of addresses it in broad strokes. With layoffs, obviously, employers need to the extent that they can, be mindful of their obligations to cash out certain benefits if they have a policy or a practice of doing that for employees that they're laying off. They need to be mindful that they need to conduct layoffs in non-discriminatory manners. There's a lot of nuances to that. Notices that they may be required to issue relative to some of the reductions in force, compliance with things like the WARN Act that provide for protections and notices relative to layoffs. Many employers under these circumstances will fall within an exempt WARN, but there are other requirements and some notice requirements they'll still apply with, even if they're exempt from the typical 60-day requirement. So there are a lot of nuances to layoffs and furloughs. Can take several hours through all of those details. But yes, a lot of employers are doing that right now, and just need to be mindful of their obligations as they go through that process.
What we're finding is that people are faced with orders from cities. This has hit the restaurant and hospitality industries pretty hard. City declares an emergency, close the doors, and you can do take, but you don't need everybody to do takeout. I did see where Amazon's trying to hire everybody who jobs. So there are others who are able, who are trying to step up. And employers, for example, I've seen dentists and doctors and some who have pretty high expense loads and fixed costs, and they're not able to keep operating because they're in place that only emergency procedures can be performed medically. Then those folks are in a position where they can't bring forces in. They don't have any work to do, but to meet out what they can afford to pay and still keep the doors open and keep on. So again, important to spend time with your advisors, considering all of your obligations, it plans, what it means. Remember that if this goes on a long time, 401k plans and other retirement may have hardship distribution provisions. They may have loan provisions. Remember, when it comes to your qualified plans, that you may need plan amendment to provide something that you want to provide to employees. So this initial few days has been really a push to get, as I say, get the liquidity out. And we've been writing and revising the articles and other materials we're putting out on sometimes every couple of hour basis to make sure that you have the most updated information. But as we move in this and we receive more guidance and regulation from the government, it's going to be really important to be careful about how you approach your obligations. I would say the thing I forgot to mention is in the Joint Internal Revenue Service Labor Notice, they indicated specifically that the Department of Labor would take a 30-day no enforcement policy where they're going to try and educate people and help them get into compliance as long as people are acting in good faith. That's pretty important because you can go forward and make your best judgments without having to worry that you're going to get a notice from the Department of Labor and a big audit. But eventually they're going to expect people to comply. So lots of complexity, but I agree with Chris, it's important to take account of your broad range of legal obligations.
We have another question for clarification. You've talked a little bit about this, but if employers are asked to pay by the employee, even if there's no source of income from the business, how does the business handle that?
Could you say it again? I didn't hear.
If the employee is expecting some form of payment, but the employee has no, or the employer has no real form of income, you know, if the business is not doing well, how does that, you know, get handled?
Well, Chris may have some ideas as well. I think people are generally doing the best they can. There are companies that have had to close their doors immediately. Again, the restaurants come immediately to mind, and that's part of the reason for the government benefits. Query whether they're around to transmit the paid sick leave and the Fmla leave. The purpose of the tax credits is to get money to the people quickly. So again, you can offset your payroll tax obligations. If you can't pay payroll, that may not be as helpful. If you've got some money in the bank and you've got, you know, things you have to work out that way. In addition, if you need a refund, the tax credits, to the extent your withholdings and tax deposits are insufficient, you can ask for a refund and the IRS will process it within 2 weeks. But if you're simply out of money, then you know, that's a more difficult question, because the whole system right now is presupposing that employers can go forward. You have the unemployment piece that would help in that case. I suspect we'll see more guidance this week. Chris, what are you thinking?
Yeah, just to add to that, I think, and it sounds to me primarily as a question about the tax credit. You know, if I'm not making money anyway, how's the tax credit going to benefit me if I have to provide these additional benefits to employees? And that's obviously more of a tax question, which is your forte. But just to clarify, if employers are still working employees, they need to make sure they can pay them, because there are obligations to pay, to timely pay. There's really not an exclusion for, well, I ran out of money. The response to that is, well, then you need to put in furloughs or layoffs. You need to take the steps necessary to either ensure your employees are getting paid in accordance with their legal entitlement, or they're being let go, so they can seek out employment or unemployment compensation elsewhere.
Thanks, Chris.
Well, and I think it's important to add to that, one of the problems we see come up fairly frequently without regard to this healthcare crisis is that employers who are struggling will pay the employees what they owe them net, but not pay the taxes because they can't afford to. And that's going to create a bigger problem no matter whether we're having this crisis or not. So.
We have another question from Gail. She wants to know if an employer can require a doctor's note for return to work if the
Chris, we're all looking at you.
Yeah. And this is, again, one of those areas where the laws themselves are very vague. They don't go into the details on it, but applying general principles under the FMLA, which in our opinion do apply, because again, remember with the Fmla Expansion Act, it takes the framework of the existing FMLA, the existing regulations, the existing body of case law, and those are going to apply to a lot of the general provisions and general requirements under that Expansion Act. Our opinion on this may change as we go forward and get regulations from the Secretary of Labor and some of the other government agencies we're waiting on. But our general answer to that question is, if one of the leave entitlements, remember there are different reasons for leave under these two laws, relates to that individual's medical condition, then yes, you certainly can, in my opinion, require proper medical documentation to ensure the employee is able to return to work. But keep in mind, a lot of those provisions, a lot of those entitlements to leave have nothing to do with the employee's medical condition. The entire Expansion Act, Fmla Expansion Act, has nothing to do with that employee's medical condition. It's about that employee's ability to take care of their kids who are under 18 years of age at home if their kids' school closed or their kids' childcare is not available. Has nothing to do with medical conditions. So employers need to be mindful of the reason for leave and the type of documentation and information they're requiring.
I'd also say that, remember, we're in a period right now where an initial statute was passed. There's a corrections bill on the horizon. I don't know how that dovetails with the Senate bill that seems stalled right now, but more legislation is coming through, and we've got notices from the government agencies that are exceeding the terms of the statute, probably in anticipation of the corrections bill. And so in an environment where the reason to keep people home is to keep a disease from spreading throughout the public, there may be different regulatory requirements, but we'll just have to see about the guidance that comes.
Okay, we have another question specific to restaurants. We have sales tax due right now, and they're trying to figure out how to stretch their cash. Is there any sort of deferral or payment plan that is currently available?
All I have seen so far is the deferrals with respect to the income tax. But we'll check with the Department of Labor and see what they're doing with respect to transaction privilege tax. The governor did on Friday extend the income tax deadlines, both payment and filing, to match the federal extensions. But as we sit here, I don't know if that's, I don't believe that's been extended to transaction privilege tax. So we'll double check and we'll let Sally know and get something posted for you on that.
That would be great. Okay, a question for Otto. If the emergency paid sick leave is addition to any current paid PTO, sick, or regular leave provided by a company.
Could you say it
Can
again?
you ask Otto if the emergency paid sick leave is in any addition to any current paid PTO leave, sick, or vacation, I would assume, provided by a company?
Yes, it is. So, and you'll remember that we mentioned earlier that the employer can't require the employee to use other leave before they use this federal leave. So yes, it's in addition to the difficulty we're going to have is the one we talked about a few minutes ago when it becomes a cash flow issue. With respect to the federal benefits, the government has provided a way through the tax credits to fully reimburse the employers for what they're having to pay out. If the employer doesn't have enough financial wherewithal to pay the other benefits, then that's a separate problem. And we'll just have to see what comes of that. But for now, yes, they're in addition.
Okay. Here's a question. What about small nonprofit employers with cash flow issues? Is there anything specific to nonprofits?
Chris, have you seen anything? I haven't seen anything
No.
specific to that.
Yeah, there's no exception as far as I'm aware for nonprofits. And just double checking the actual text of the statute right now, the definition of employer really does include nonprofits, with the caveat, there is one possible caveat that truly small employers should be aware of. Both of these enactments only apply to employers engaged in interstate commerce. Now, that being said, interstate commerce is interpreted very, very broadly. Almost every employer is considered to be engaged in interstate commerce. It's a very easy test. It's under Section 501 of the Labor Management Relations Act. And traditionally, almost every employer is found to be engaged in interstate commerce. So that's one possible caveat, is if they're not required to comply with these enactments. I don't see another exclusion for nonprofits other than that possibility.
Yeah, I think that's true with respect to this act, talking about the Family First Virus Response Act, but more generally are other statutes coming out. That I believe the bill that's being batted back and forth in the Senate right now is about a much more broad response. And I can tell you that in last week's meetings with the congressional delegation, that issue was brought up several times specifically because the nonprofits are on the front line providing the services to the people who need them and who are probably the most vulnerable. So as we sit here, I'm unaware that there's anything yet. We'll go back and look and post what we find. But that has been raised. I expect in the meetings later today it will be raised again because it's such a critical issue.
Okay, this is from the same person that asked the question about restaurants. Currently, the amount of layoffs that a company has affects their contribution rate to unemployment fund. Will this involuntary layoff affect a company contribution rate when it comes to back online after we are allowed to open again as restaurants? It feels like we will be penalized when we come back online. Our employer taxes will increase because of this. Is this on someone's agenda to look at?
Fortunately, Governor Ducey thought of that.
Oh.
So I will read you his very words.
Okay.
In adjusting employer contribution rates for the Unemployment Compensation Fund established by ARS 23701, the Arizona Department of Economic Security may not consider unemployment benefits granted pursuant to this executive order against an employee's account. Now that's only half the question you asked, because if you're not paying wages and you're not making deposits, then your account isn't going up. But at least the unemployment benefits and claims shouldn't be counted against your account.
Okay, we have a question in the chat. Can companies legally freeze the use of available PTO when they are cut hours and pay? Still working, but cutting hours.
Chris, what do you think?
It's going to depend largely on their policies, their independent legal requirements. So for instance, and this is a big issue in Arizona, there's a 5-day sick leave law. That cannot be cut. If somebody has 5 accumulated sick days, you can't unilaterally cut them as an employer. That would violate the state law on that. What employers are also need to be cognizant of are really two principles when it comes to their independent vacation or PTO policies. Number one, if it's guaranteed to employees, it's written in that they will accrue it, that they've earned it, they have a right to use it. Employers generally cannot unilaterally cut that away during the term of somebody's employment. They need to look at their policies, they need to look at what they've promised employees, but it's like any other contract. If you've made a promise, a guaranteed to employees, unilaterally cutting what they've already earned may violate the contract, may constitute a breach, and may entitle the employee to pursue recovery for those. The second aspect is, it goes back to my point about the Arizona sick leave law. A lot of employers are providing those 5 days of paid sick leave through their generic PTO policy. It's very tough now, if they've done it that way, to distinguish independent PTO provided solely by the employer and the 5 days of sick leave that are guaranteed by statute. It's all now mixed together into one bucket. And so employers are going to have a very difficult time slicing away the difference between a statutory right in that context and just merely gratuitous benefits they may be providing. But again, it's very dangerous. Employers that are contemplating doing it really need to look very closely at the law, very closely what they've promised employees, and make sure they're not violating the promised benefits that they've already granted or agreed to grant.
Well, and that applies across your benefit plan spectrum. Again, you need to be reviewing all of your benefit plans, deciding in light of your current financial circumstances, your current work circumstances, who's working, who's not, how are they working away from home. You have all the regular obligations from your 401k plan, your health plans, you have OSHA obligations, a variety of things that you need to look at that are independent of these emergency things that the government is doing.
Okay, we have a couple more questions. Is it legally wise to modify staff job descriptions, duties now, in order to maintain a person's employment? In other words, can one offer a lesser paying job with a different title to a salaried worker?
I think there's some peril in doing that. I think we're going to see some of these regulations have retroactive effect. Remember that, at least with respect to the statutes we're talking about, the effective date of the rules can be up to 15 days, but doesn't necessarily go to the 15 days. So I'd be a little cautious about modifying someone's position in advance. Chris, do you have a different thought?
Yeah, and it does depend. I mean, if there's some effort to modify somebody's position or pay or things like that to avoid application of the statutes, I agree with you that that could be interpreted as unlawful interference or retaliation, depending on when it's implemented. But as a general measure, if we're just talking about an employer who's got a job position they need to cut, they recognize, look, I don't need somebody in this position, but hey, I can transfer them out of that job into another open position, then by all means, I mean, there's no reason they can't consider doing that. What we want to be mindful of, though, too, is that they're not essentially taking somebody who's doing job A, they're just trying to reduce, whatever compensation or pay they're getting by calling it job B, even though they're doing the same job. They don't want to get into a situation where they're creating a bit of a subterfuge on what it is that they're truly trying to do. Now, that being said, I've also advised a lot of employers right now of their rights to work with their employees, dialogue with their employees about pay reductions. A lot of, especially high-level management, are all at many companies right now are taking pay reductions to continue rolling forward. We've seen CEOs of some of the bigger companies, they've just given up their pay for the next year.
Well, we've seen the same thing with smaller companies. As employees are so drastically affected right now, they've been doing the same thing.
Yeah, and there's nothing wrong with that. Nothing wrong with it. You just want to make sure it's done in a legally compliant manner, that they're not running afoul of FLSA regulations. That's what they want to take a look at when they're doing it.
And you certainly don't want to do it in a way that discriminates against any particular group.
Agreed.
Okay. Someone looking for clarification, just want to make sure FMLA is still 1 year full-time, but the Sick Leave Act is available to employees after 30 days.
Just to clarify that, so there are two different sick leave entitlements with these new laws. The first one is the Fmla Expansion Act. Okay, so The traditional FMLA structure remains in place, and that applies to employers with 50 or more employees. You have to be there a year. The FMLA expansion portion of it applies to smaller employers, employers of 499 employees or less, and that kicks in at 30 days. The separate law, the sick leave law, kicks in from day one. There is no 30-day wait window under that separate sick leave law. So just for clarification, again, there are now paid sick leave rights under the FMLA Expansion Act, and there are paid sick leave rights under the sick leave law. They do operate slightly different, so you have to be aware of the rights and responsibilities under those two different laws.
The other thing I would add is that, and we may have mentioned it before, but this new statute gives the Secretary of Labor the ability to exclude employers with, I think, less than 50 employees. And so back to the question of what do I do if I can't afford it? If you've got less than 50 employees, there may be regulatory relief coming so that you don't have to run the government's bank, but we'll find out.
Okay, it looks like a follow-up.
5-0.
A follow-up to that question. It sounds like it's better for an employer to lay off to reduce the risk to employers instead of redoing job descriptions or furlough.
Chris, what do you think?
And this is a heavy debate. Do I go with layoff or furlough? And my response to it is always, it depends on your business needs. This has to be evaluated on a case-by-case, employer-by-employer basis. There's no one-size-fits-all answer to that question. Now, that being said, if the employer is of the conclusion that they are going to be down for a truly extended period, their preferred course may be to go with layoff rather than a furlough. Furloughs generally are looked at more short-term, maybe a matter of a few months, depending on the circumstances. But if you're very confident as an employer that you're going to be down for an extended period of time because of the economy and the recoup period, you're probably better going to a layoff. One thing employers should also be mindful of is while they can lay employees off, while they can furlough employees, when it comes to these new laws, if they're selecting out employees who they think are most likely to use the benefits under these laws, that may be perceived as interference. It's an unfortunate tendency, and I understand everybody's struggling. They're trying to figure out how their businesses are going to go forward in these dark economic times, and that's all understandable. But to pick out the parents who've got young kids and lay them off over others, that you're inviting a potential legal claim. You don't want to do those kinds of things.
Chris, can you define the difference between a layoff and a furlough?
Certainly, and that's a question I've been getting a lot of lately. It's a very common question. Generally speaking, and the terms, they kind of have more of a meaning that's come by way of just an understanding rather than a clear definitional distinction. But generally speaking, a layoff is when the employee is terminated. You go through the process of terminating them, you issue COBRA notices, you treat them like any other termination, except under these situations, it's for economic reasons rather than conduct or anything like that. A furlough, you're still keeping the employee on your payroll. You're just sending them home and telling them we don't have work for you, you're not going to get paid during the time that you're away, and we'll give you a call when we're ready to bring you back to work. There's usually not the same formal level of separation, and there are varying types of furloughs.
Continue during that time?
I'm sorry, what?
Benefits continue during that time?
Most of them generally do, but it's going to depend on the circumstances and how the employer sets up the particular furlough. Employers also need to look at their health policies with their healthcare provider, their insurance provider, because those policies will dictate who does and does not qualify under that healthcare plan for coverage. And so they need to start looking at all of those things if they are considering a furlough. And there's also different kinds of furloughs too, I wanted to point out. Sometimes some employers have rolling furloughs where different employees, a different week of the month will take that week off. I mean, there are all kinds of variations that employers can put into place. It's not a one-size-fits-all solution.
But I want to re-highlight that if someone is terminated or furloughed for an extensive period of time, that can cause a termination event under the health plan. That can trigger the need to give a COBRA notice. You have all these independent requirements with respect to your benefits and with respect to your workforce that you need to consider. So a knee-jerk reaction is not the best. Some employers know already today that they have to close everything down right now, and or they won't be able to open back up when this is over. If this is a 2-week thing, they may be able to get back. If it goes on longer, or if employers know that they can continue, the paid sick leave benefits are there to kind of help bridge the gap for 10 days. Arizona unemployment, the same thing. So employers have some resources that their employees can tap into, but you've got to coordinate everything you're doing and all the decisions you're making with all of your legal obligations, so that you're managing your pay and benefits correctly.
Okay, we have a question from Facebook Live. Employees only paid versus commission. Sales have gone to zero. We do still have benefits. What should they do?
Can you read it again?
I'm reading it the way it's written. Employees only paid via commission. So no regular paycheck, just commission. Sales have gone to zero. We do still have benefits. What should they do?
Well, again, those employees are still entitled to the federal benefits. There are some formulas in the statutes for considering what their regular rate of pay is, and so they would still be entitled to the paid sick leave if they can't work. If they're still trying to work, you can still pay them, presumably. Chris, do you think if they're still working but they're having to work from home and they're not getting results, do you think they can get benefits under the paid sick leave act if they're...
Absolutely, and so there's a lot of big picture issues that are encapsulated in that question, and the biggest one I'd start with is if the employee's unable to generate any sort of sales, I'm presuming they're in a sales role, are those the employees that should be furloughed or laid off? I mean, that's the first question the employer has to ask. But if they're continuing to employ the individual's out trying to get sales, I'm going to presume for purposes of the question that they're an outside salesperson, that they've been properly classified under the FLSA, that they fall within a category where they can only be paid commissions. If there's an improper classification, that's a problem unto itself that needs to be addressed separately. But assuming that to be the case, you can still employ the individual. You can still have them trying to make sales. They'll get the commissions that they get along the way. When it comes to benefits, other employment benefits, the employer wants to continue to provide those. You know, if the employee is eligible for health benefits and things like that, if the individual's employed on that basis, they should still be getting those benefits, and they would have the right to exercise the sick leave under these new laws. They're an employee, they're employed there, they're entitled to take the sick leave, and there's some averaging. There are formulas under both of these new sick leave entitlements that allow the employer to calculate what's called the regular rate under the FLSA, and the regular rate includes the commissions they've been earning. So there is a calculus that needs to be done to ensure that the employee, while they're out, is getting, essentially 2/3 of the equivalent of what their commissions were. All of that has to be factored in determining how much pay they're going to get while they're out on sick leave under either the Expansion Act provision or the new sick leave law.
Okay. One more two-part question. Can you furlough by reducing salaried hours from 40 to 20, and can a furloughed person receive unemployment?
Yes, I think the answer to both is yes. Again, you need to avoid being discriminatory. But if you give everyone an across-the-board reduction, for example, I see no problems with that. And clearly, the unemployment statutes provide that if there are no other benefits available, then the unemployment is available. I think that's one important thing. We've talked a lot about sick leave, but under statutes, you don't have to be sick to get these benefits. My guess is that as we see further guidance develop, you may not necessarily need to be sick to get Arizona sick paid leave, because public emergency is one of the qualifying events. So I think, Chris, do you have any further thoughts?
And just one thing employers need to be mindful of in doing some kind of furlough with salaried employees, especially when you're dropping hours. If they're salaried exempt, the employer has to make sure that they're making the minimum requirement for the salaried exemption, the $35,000, I think it's $35,568 on an annualized basis that the salaried exempt person has to be making. And the employer cannot dip into the regular salary because that defeats the salary basis test. There's Department of Labor regulations on this. Granted, they're all from, before COVID-19 came into place. But the Department of Labor has said if you have a salaried employee, they're salaried exempt, you cannot reduce their salary during the week that they work less than the full hours. So if they're reduced from 40 to 20, you can't cut their salary to compensate from one week to the next. The employer, however, and this is in Department of Labor opinion letters and regulations, the employer, however, can make a sort of one-time salary reduction and say on a going forward basis, you're only going to be earning 70% of salary or 60% of salary. That's fine, but it cannot be modified from one week to another or to the next or 1 month to the next. It has to be really on a, I use the term permanent with hesitation, but for a concrete period of time that's semi-permanent going forward, whether it's 3 months, 6 months, 9 months, whatever, they can make that reduction. But again, it's a one-time reduction. It can't be modified from 1 week to the next. And it always still has to be higher than the minimum salary requirement. And those rules are only with respect to salary exempt under the FLSA. It doesn't apply to non-exempt who are getting overtime anyway.
Well, and keep in mind that the Department of Labor's non-enforcement policy for this purpose is relatively short-term, and it expects everybody to operate on a good faith basis. So analyzing and documenting these kinds of considerations is pretty important to establishing good faith.
We do not have any more questions. We do have several people that have just wanted to say thank you for you guys taking the time to be here and sharing the information. So I guess as a follow-up, if any of our members have more questions, how should they best reach out to you guys? I mean, we can email them information, but do you have a phone number, email address? Is there anything you want to share?
So I'll give you my email address, which is oshill@jsslaw.com. And my phone number is 602-684-9228. Chris?
Yes, mine is Chris Mason at jsslaw.com. So it's CHRISMASON at jsslaw.com. And my phone number is 602-262-5817.
Great. Okay. So this will be on our website at mesachamber.org for anybody who wants to go back and review any of this or share it with others. And again, we've got some information that because our folks had actually signed in, we've got their emails and we'll send them information later today from Jennings Strauss. Thank you both very much for your time.
Thanks for having us.